Hello, good morning, everybody. Welcome to Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you, everyone, so much for being here. I'm in a great mood. I'm juiced. I'm ready to go. Kaylin's juiced. Tiffany's juiced. Everybody's excited about this morning, and that's because of you guys, because you sent us so many great questions. First of all, to introduce myself, my name is Joshua Ritter. I am a former prosecutor with the LA District Attorney's Office. I was there for over 10 years. Then I left to go into private practice as a criminal defense attorney. And so this is Courtroom Confidential, where we try our best to present to you both sides of the courtroom. And this is Sunday Fun Day, where we answer your questions that you have sent us in voice messages throughout the week. And we're going to answer them live today. And that's why we're so excited about today, is because you sent us a lot of really great questions. So hello to Black Witter and to Crazy Mary Jo and to Forrest Nelson and Becky B. And I know that everybody's beside themselves because we can't seem to fix the names in the chat, but we're working on it. Please don't set the room on fire. We're figuring it out. Dr. Von de K became a member. Thank you so much for that, Doctor. Miss Linda 12 became a YouTube member. Appreciate you. Hippie Mimi became a YouTube member. I love it. Jump on board, everybody. And Crazy Mom RN has been a member for 7 months, and she's super juiced. All right. So let's get rolling on this. A lot to get through today. First of all, before we start, please hit the like button if you haven't already. Please subscribe if you haven't already. Please share this with somebody. Check out the membership program. Johnny Knoxville says, shout out, moms. I am cooking my first brisket chili today. Got up at 9 and I'm shot. I don't know how you raised us in the 80s. My utmost respect. I appreciate that. Good for you, man. Good for you trying to tackle that, though. All right. Arizona Gal says, happy Sunday, fun day. Happy Sunday from sunny Tucson, Arizona. You guys rock, and I love this community. Well, we love you right back, and we appreciate you being here and for contributing and supporting the channel. All right. Should we jump into this? We got a lot of good ones. Let me get myself figured out, and we'll get rolling on these.
Hi, Josh. Hi, brilliant mods. Hi, chat. This is Little Miss Red Velvet from the UK. Just want to say hi to everyone. Loving the channel. Keep doing the brilliant work that you're doing, Josh. Also, we'd just like to say, what's next for the channel? What would you really, really like to do? If you could have any guest on the channel, who would it be? Take care. Thanks. Bye.
Thank you so much, Little Miss Red Velvet. I love that name. Calling from the UK. Right off the bat, we're traveling over the pond to the UK. So let's put the England on the map. What an interesting question. What's next for the channel? Well, we're working on stuff. I will say that. We are a very hungry group of people, and we're always trying to improve what we do here. We're always trying to come up with ideas that we think that you guys might enjoy, come up with something fun, something different. That's what we're always trying to do, too, is make it a little bit fun and a little bit different. And so we do have some things in the works, stuff I can't exactly share with you just yet. And I hate to be such a tease about that, but some exciting stuff coming up. We hope, if it all comes together. But who would be my next guest if I could interview anybody? Well, you know, I mean, first person that probably comes to mind is Bill Thompson, obviously the prosecutor on the Bryan Kohberger case. I think I would love to sit him down. I admire so much of what that man went through and so much of what he did, but then I also have a lot of questions for him, and I'm sure you guys do too. Questions like, why didn't you sit that maniac down ahead of time and get some answers to some things? He would be a good one. If anybody knows Bill, tell him I'd love to speak to him. And then I started thinking about, well, who's like a OG true crime person that might be fun to talk to? I thought about Keith Morrison. Keith Morrison is like the godfather of true crime. I think I'd love to sit down with him just because he seems like he'd be an interesting character. And then I thought, you know what, who you guys would all enjoy, who I would enjoy as well, is Emily Baker. I mean, she's been, at the top of her game when it comes to this kind of true crime legal coverage. And she has such a wonderful community and strong following of people. And we both worked at the LA District Attorney's Office together. So we didn't know each other when we were there. We knew of each other because it's kind of it's a large office, but not that large. But I'd love to chat with her too. Maybe sit her down for one of those conversation series that we've been doing. So those are on my wish list. If anybody knows any of them, reach out, say we'd love to chat. But great question, Little Miss Red Velvet, one of my favorite types of cakes, by the way, calling from the UK for kicking us off this morning. All right, let's keep it rolling.
Hi, Josh and friends. This is Veronica Collins. I'm commenting near Norman, Oklahoma. I'm a longtime fan. Even I was your fan before Courtroom Confidential. Here's my question. With BK, the jerk from Washington State University, will his student loans be forgiven since he's going to be in prison for life? Just wondering. As always, love from Oklahoma. Thank you.
Veronica calling from Norman, Oklahoma. Let's put you on the map. Oh, right outside of Oklahoma City. Good to have you. Good to hear from you. Thank you so much for all the support over the years. Before you are from the BCC times, before Courtroom Confidential, which was a while ago, and I'm so appreciative that you've stuck with us for all this time. Such an interesting question. And I love this because we think about all the consequences and the fallout from a case like this, and the defendant being sentenced and he's going off to prison for the rest of his life. And there's a lot of other consequences that we don't ever think about. But Veronica did. She said, well, the guy still had a bunch of student loans. I'm sure he did. What happens to those student loans? And God forbid, will those be forgiven? Here's my answer. I don't know. I do not know how the federal government would treat this, but I will tell you that I do not think committing 4 murders and being sentenced to life is exactly in the column of things that would forgive your student loans. So I imagine that they're still due. I imagine that they still would like to collect in the hierarchy of people that he owes money to, though. I don't think that they're going to come towards the top because he owes a lot of money in restitution towards the victims' families in this case, and court fines and fees and everything else. So he'll probably default on his student loans, Veronica. So on top of everything else, I guess he's going to have really horrible credit as well. But interesting question, an interesting way to think about it, Veronica. Thank you for that. Calling from Norman, Oklahoma. Where are we going to next? Here we go.
Hey, Josh, Diane from Pittsburgh. First of all, I want to say thank you so much for setting up Courtroom Confidential, a great place to come and learn and discuss. And I can't thank you enough. Kudos to you. My question is regarding expert witnesses. Have you ever had a witness that wasn't accepted by opposing counsel at trial as an expert? Or have you ever heard of it happening? If so, what did or do you do at that point? What was your plan B? Thanks, Josh. Hope to hear your answer. And again, thank you so much for Sunday Fun Days especially. Bye.
Well, thank you, Diane from Pittsburgh. Let's put you on the map. I appreciate the kind words. That's so sweet of you to say. We're happy to be doing the hard work over here, and we're happy that you appreciate it. And I love your question. Diane wants to know about expert witnesses and if they're not accepted. And I think the best way to get into that is to start talking about what is the process behind an expert witness being accepted? And we've chatted a little bit about that before, but it's good for a refresher. So each jurisdiction has a different standard, not different for every single jurisdiction, but they mainly fall into two categories. We've heard these names before, but you've heard about a Daubert hearing and you've heard about a Frye hearing. They are two cases, Supreme Court cases, that each state follows, and they're similar for the most part, I should say. In California, we follow what's called a Kelly-Frye system, meaning they go by the U.S. Supreme Court case of Frye, which was a federal case, but there was a California case called Kelly, which basically stood for the same proposition. You remember in the Karen Reed case out of Massachusetts, they had Daubert hearings. That was the standard that they used there. If you've been, there she is. If you've been following the Rex Heuermann case out of New York, they still follow the Frye standard. So what's the difference between the two, and how do they apply to a expert being qualified? Frye focuses on general acceptance in the scientific community. It's kind of a very straightforward standard saying, is this generally accepted in the scientific community? You remember in the Rex Heuermann case, they're having their Frye hearing. There still hasn't been a decision about this. And one of the issues that it's coming down to is that the prosecutors want to use a type of genetic analysis, DNA analysis, that has not been used in New York courts before. And because of that, it's able to be challenged because they're saying, well, it's not been accepted by the scientific community here in New York. And the prosecutors are trying to say, but yes, it has been accepted in the scientific community broadly. And that's what it's all going to come down to is, does the judge believe that this is a scientifically accepted practice? And that's usually what you're talking about with experts. Is most experts, to your question, Diane, have been long established experts, and they're talking about long established parts of science. It's only when we get into kind of breaking, cutting edge science, or experts who've never testified before, that you start to deal with these types of issues. Daubert, on the other hand, emphasizes relevance and reliability. They consider factors. This is what was used in the Karen Reed case. Factor 1, can the technique be tested for reliability? 2, is it subject to peer review? 3, is there a potential rate of error? 4, is there existence of standards? 5, is it generally accepted? All of these things, though, kind of go to the same concept of if it's generally scientifically accepted in the scientific community, because the scientific community does its own vetting, right? If it's accepted in the scientific community, you can imagine it's a technique that's been tested. You can imagine it's been peer reviewed. You can imagine it has the potential for rate of error has been analyzed thoroughly. So again, usually these questions don't come up all that much in everyday practice because you're dealing with experts who've testified many, many times before and on usually established areas of science. But your question was more along the lines of, have I ever had an expert who hasn't been qualified? I have not, because usually if I'm calling an expert, both as the prosecution and defense, I'm calling an expert who's testified many, many times before and testified about what they're going to testify to many, many times before. And it's well established. I have not run across a situation, and I thought long and hard about this, where there was really such a kind of groundbreaking, cutting edge scientific arena that they wanted to get into that the judge felt was too cutting edge, not scientifically accepted, or they felt that that expert was not qualified. The one place where I can think of where it was, we had quite a bit of litigation about it was, many of you guys know this, Alan Jackson prosecuted Phil Spector for the murder of Lana Clarkson. I was his law clerk way back in the day when we did this. And during the second trial, much of the defense relied upon the idea that they felt that Lana Clarkson had taken her own life. And they wanted to go through her journals and her emails and a bunch of kind of history that she had. And they called an expert in this topic, on the topic of suicide. And a psychologist they wanted to call, who was an expert, to talk about, there he is, that yes, I'm reading her diary, I'm reading her journals, I'm reading letters that she wrote to her family, and I feel that she was prone towards self-harm. We felt that that was way too broad of a opinion to arrive at. A lot of litigation. The judge ended up allowing that expert to testify. Now, because that expert was kind of out on a limb with their testimony, it ended up backfiring, and we were able to kind of exploit the bad analysis that expert had done. But that expert was qualified. As far as like, what do you do if there he is? Look at that. First of all, AJ looks like he's 12 and borrowed his father's suit to sit there. And then I have way more brown hair than I do right now. But the answer is, what do you do for plan B? Is you figure out another expert, or you figure out that radical kind of scientific theory you're planning on arguing is just not going to be used. So thank you for finding that one, Kaylin. Digging deep into the archives for that one. Young Josh. Yeah, that's what, 2008? God, we're going on a long time ago. So thank you for the question. So much, Diane from Pittsburgh. Appreciate all the kind words and appreciate your question. Let's keep it rolling here.
Hello, Joshua, mods, crew, chat, guests, everybody. Alicia K. Mayo, Humboldt, Tennessee here. Joshua, what's the latest on the slimy little amoeba, Austin Drummond, and his associates? Our local WBBJ TV station released some documents regarding his associates, and everything that was charged in there seems to be from before the abandoned baby quadruple murder case here in Tennessee. Appreciate everything y'all do. Appreciate you, Joshua. Appreciate you, Kaylin. Appreciate you, Tiffany, and all the mods. Plus the crew, the chat, all our guests. Y'all have a great Sunday Funday. Thanks. Bye.
Alicia K. Mayo, Humboldt, Tennessee. Putting Humboldt back on the map. Alicia K. Mayo, always with the kind words, always thanking everybody, the mods and Kaylin and Tiffany. We appreciate you so much. This one's right in your backyard. Crazy RN, Crazy Mom RN. Thank you so much for the gift of memberships. Appreciate that. Laura Waldy for gifting a membership. Appreciate that. Right in your backyard, Alicia K. Mayo, was this horrific murder case that we're going to continue to follow. There he is. His name is Austin Drummond. What we're finding out, the latest news on this is, I think this is something we've already known, but the latest news is they do believe that it was somehow connected with the fact that he was dating. And what's strange to me about this case is that the person he is dating has not been named as a suspect. They have not talked about what role she played in all of this. But they do know that the connection that he had to these four people, these beautiful people who lost their lives, is that he was dating the sister of a woman by the name of Courtney Rose. Courtney Rose was the grandmother to the child that was abandoned at a random home. And that's how this whole thing started. An infant was abandoned at a random home. Then they find out later a quadruple murder had taken place some distance away. And that took the lives of James Wilson, Adriana Williams, Braden Williams, and Courtney Rose, who were the mother and father of the infant, the grandmother, like I said, of the infant, and the uncle of the infant. And there's the baby there. And Courtney Rose's sister was dating Austin Drummond. That's what we know about the connection so far. He has been arrested after a manhunt. He is facing the death penalty. That's what prosecutors say they intend to do. Along with him we have the arrest of Tanaka Brown. I'm reading this from left to right. Diaro Sanders and Giovante Thomas. They have all been arrested and charged with accessory after the fact, meaning law enforcement does not believe that they helped him in the planning or the execution of these 4 people, but they did help him in evading capture and perhaps providing him with vehicles or money or food or lodging or whatever it was during that time that he was on the run. He has waived his speedy trial rights, which is not shocking, meaning that his prelim isn't going to happen anytime soon. If you don't waive those rights, usually the prelim takes place within about 10 days in most jurisdictions. So his prelim is going to be put off for quite a bit. His next court date is September 4th. This is a case that we're going to be following closely. Just a really tragic, horrible case. He's just an incredibly violent person. Allegedly committed a horrific crime. I'm glad that he's been captured, but I do want to know what caused all this. What was the motive behind this? What possibly could have been the reason for him to take a gun and execute 4 people? And then, for whatever reason, what caused him to have the sliver of humanity to take that infant and not leave it there to die, but to actually take the infant and leave it in someone's front yard? That's the other interesting thing we found out, is that apparently whoever dropped off the baby made sure that neighbors or standers by saw the baby before they got in their vehicle and took off. Just a horrific, nightmarish, but also very strange and interesting case. Thank you so much, Alicia K. Mayo. I know that's one that's close to you and that you're following closely, and so we will as well. All right, let's keep it moving here.
Hi, Josh and Courtroom Confidential crew. My name's Erica, and I'm from Hattiesburg. And I was calling regarding the discussion you were having about the judge who didn't accept the plea deal and did his own sentencing. And it got me to thinking about Judge Boyd in Texas. She live streams her court. And when she's going over the, whatever it's called, when making sure that the defendant understands their rights, she says, something along the lines of, you understand that I don't have to sentence you to what you and the prosecution agreed to. However, if I don't sentence you to that, you can take back your plea agreement and go to trial. And the fact that you pled guilty for the plea agreement will not be held against you. So I'm wondering if that's a jurisdictional thing, a judge thing, or based off of the severity of the crime, if that's how they determine it would be held against them or not. Thanks for all you do. Appreciate you. Bye.
Erica, appreciate you from Hattiesburg, Mississippi. Let's put you on the map. I think, is that our first caller out of Mississippi? No. Okay. But I first out of Hattiesburg. Oh yeah, Jackson. Thank you, Erica. What a great question. Erica is referencing a case that we talked about. I think it was on last week's Sunday Fun Day, and I wish I had put up the picture of it, but it was a bizarre case. No one was paying attention to this case until it became time for the plea, and then the videotape of the plea falling apart kind of went viral. And just to set you up, this was a woman who is accused of stalking a ex-boyfriend of hers. She had been charged with a misdemeanor. Now she's going to court. The prosecution and defense present to the judge, hey, here's the plea agreement. She's going to go ahead and plead. And this is the sentence that she's intending to receive. The judge takes the plea and then says, here's my sentence, and starts to sentence her, and then says, the first 7 days of your probation will be served in custody. And defense attorney jumps out of his seat like a firecracker went off and says, wait a minute, that's not our agreement. And the judge says, well, that's not any agreement you had with me. And I'm the one taking the plea, and I'm the one doing the sentencing, and I'm sentencing her to 7 days in jail. Defendant starts to lose her mind. She's crying in court. Defense attorney says, well, we want to withdraw the plea. Judge says, on what basis? There she is. On what basis? Just because you don't like it? And he says, no, because you didn't give us an opportunity to talk to you about it. Anyway, everybody gets into a pissing match with each other. She goes back into custody. I actually need to look into how this all ended up. I have a sneaking suspicion it ended up with her getting the plea deal that she had bargained with the prosecution. But the judge was making a point there more than anything. I think that judge personally just didn't like the defense attorney. He's making a point there that I'm the one who makes the decision on sentencing, not you. And that is true. And Erica says that she watches, and I had not been aware of this channel, but Judge Stephanie Boyd has a YouTube channel where she kind of live streams herself in court, which is becoming more common. And I applaud it because I think that's very cool to see in these courts where it's not some big celebrity case. It's just everyday court. How does this stuff take place? What goes down? What are the ugly inner workings of everyday court? And she tells people during a plea, I don't have to accept the plea. I can sentence you to what I like. If you don't like it, you can withdraw the plea. And that is, for the most part, true. In practice, in most jurisdictions, though, judges realize that in order to keep the big conveyor belt of crime moving down the road, it's not something where they want to interfere on every single case. For the most part, prosecution and defense get together. In fact, they're the ones who know the most about the case. They're the ones who've seen all the evidence and police reports. They get together. They say, here's what we think is acceptable. They go to the judge. They go, Your Honor, this is what we're going to plead to. Judge says, no problem. Takes the plea, sentences the person. You move on to case number 2 on the calendar of 42 cases you've got that day. If judges interjected on every single one of them, it would gunk up the work so bad we couldn't do, quote unquote, justice. There are situations where a judge will say, well, wait a minute. Why is this person getting this particularly great deal? Why is this person getting a particularly bad deal? I've had a situation where I worked out a plea deal with a prosecutor and the judge was not happy with it. Added a couple of little bells and whistles that my client wasn't too pleased with, but we eventually got it over the finish line. But one huge exception to all of this is federal court. Federal court is not the Wild West, but when it comes to pleas, it is a total leap of faith. There is no, this is what we bargained. It is, here's what we will argue in court as the prosecution. Here's what the defense is going to argue in court. Here's kind of the range of what we think you're going to be sentenced to, but we're going to go in front of a judge and you just have to kind of take what the judge gives you. It is terrifying for defendants and defense attorneys for the most part, because we're so used to knowing, sitting down with your client and going, this is what you're going to do. This is how long it's going to be. This is what you're going to have to deal with. But here it's, hey, we've done the best that we can. You cooperated, you earned points, you did whatever you could, and now we're going to leave it up to a judge. And some judges are stricter than others. So the end of the day, the answer is that's part of taking a plea. The sentencing is within the purview of the judge, not the prosecution. What you're charged with is in the purview of the prosecution. The prosecution can change the charges, but the judge is the one who does the sentencing. So, but all of that being said, for the most part, Erica, if you ever get arrested, you probably know what you're going to be sentenced to. But don't get arrested. But if you do, call me. But thank you so much for calling. You're fantastic. All right, let's keep it rolling here.
Good morning, Courtroom Confidential, Josh, crew, everybody out there listening. This is Fauna Eastep up in Coeur d'Alene, Idaho. And I had a question regarding appellate lawyers. Stephan Sterns and BK have both admitted guilt and have waived appeals. So does that mean that they will not have an automatically or will get a court-appointed appellate lawyer paid for by the taxpayers, or do they still get one even though they have agreed not to appeal their trial cases? Just kind of curious how that all works, since how there's been a lot of buzz about BK still going to file an appeal? So looking forward to your answer. Can't wait to hear it. Thanks and have a great day.
Fauna from beautiful Coeur d'Alene, Idaho. Thank you so much for calling. Good to hear from you again. We're talking about a case that's kind of up in your neck of the woods with Bryan Kohberger and also Stephan Sterns. They both found a resolution within days of each other. And this issue of waiving your right to appeal has become quite a hot topic. Let me tell you this. The wheel wasn't reinvented with these two cases. All pleas involve waiver of appeal. I mean, if you think about it, the prosecution and the defense have come to an agreement, and both of them want assurances that that's the way it's going to stay. The prosecution wants to, they don't want some sort of, rug pulled out from underneath them, some last second trickaroo where they give the defendant some great deal and then down the line he appeals it anyways and gets out of all of this. Okay, so there is a lot of waivers that take place in appeals. You're waiving a bunch of different rights when you enter into a plea. You're waiving your right to trial. You're waiving your right to cross-examine witnesses. You're waiving your right to testify. All of these things, including your right to appeal. This only became an issue, I think, in Bryan Kohberger because we kept reminding people that that was an important part of the plea deal, and it is an important part of the plea deal. And then Judge Hippler made this kind of off-the-cuff comment where he talked about whether or not that actually means he can't appeal, and everybody lost their minds. Here's the thing about it. With any right that you make a waiver of a right, you have to do so knowingly, voluntarily, and intelligently. That's always true. If there's evidence that you didn't do it knowingly, voluntarily, and intelligently, you can withdraw your plea, your waiver at some point. That's why these pleas are so detailed, why the judge will ask the person several different times in several different ways what appears to be the same question, because this is not everybody's first rodeo, and they're trying to ensure that there's no chance that he could later on argue it was not knowingly, voluntarily, and intelligently given. Or that the person can argue that they had ineffective assistance of counsel. They will ask them, did you talk to your attorney? Did your attorney explain everything to you? They'll ask the attorney, did you have enough time? Were you able to explain everything? Were you able to thoroughly investigate? And everybody's going on the record to protect against any possible argument about ineffective assistance of counsel. Okay. A waiver of appeals is a rock solid waiver. Now, your question though, Fauna, is will he be appointed an appellate attorney? That's a different thing. I don't know the actual answer to that. I looked into it, but my sneaking suspicion is he probably will be appointed an attorney, because your ability to have legal counsel and representation is different than your ability to actually do something with that, if that makes sense. In other words, I imagine they would feel that it would somehow be an abuse of his constitutional rights because he didn't waive right to counsel. He waived right to appeal. I feel like they would feel that it was an abuse of his constitutional rights if an appellate attorney didn't look at his case or wasn't available to look at his case to make sure that it was done knowingly, voluntarily, and intelligently, or to make sure that there was not ineffective assistance of counsel, or to make sure that he had the ability to ask questions if he wanted to. Now, an appellate attorney being assigned does not mean that he can then go ahead and file an appeal. Any attempt to file an appeal will be met by his waiver of appeal and will result in him not being successful in those efforts. I don't know if I cleared things up. I don't know if I made them more confusing. All I can tell you is that this is not the first time this has ever been done. It's done all of the time, and it is a rock solid ability to make sure that someone remains in prison and we don't hear about their appeals again and again and again down the road. Fauna, you're fantastic. I appreciate you asking the question. Let's keep it rolling here, huh? Where are we going next, Kaylin? Not my fault. I'm pressing all the buttons.
Hi, Josh. This is Faye from Buffalo, New York. I really enjoy your content, and I'm hoping that this question will get addressed in the live on Sunday, though there's a reasonable chance I might end up having to relegate it to the replay crew. Anyhow, my question is regarding the Neha Gupta situation in Florida and the death of her daughter. I have so many questions. First of all, if the facts of the case as presented by the coroner suggest that her daughter did not drown in the pool, but was perhaps smothered due to some of the findings, in her mouth, the lack of water in her lungs, how on earth is this not a murder charge? And that negligent homicide, what events could lead to just it being negligent homicide? And could anything having to do with Neha Gupta's mental health have somehow caused the state to bring a lesser charge? And then the other part of my question is, what if the jury feels that she is being significantly undercharged? Usually the problem is that there's a thought that perhaps there was an overcharge, but in this case, it's the other direction. If the jury doesn't feel that that is an appropriate charge, what do? Just go with a guilty verdict, even though they think it's under, or could they say not guilty because they don't think this was the crime that occurred and that it was something more severe, and almost send it back? Or is it become a mistrial? It's a very strange situation, and I'd love to hear your thoughts about it. Thank you so much, and I look forward to Sunday Fun Day. Bye.
Faye, thank you so much. Faye calling from Buffalo, New York. Let's put Buffalo, New York on the map. Great question. I love that you brought up this case, because this case is fascinating to me. It's also very tragic, but it's got a lot of legal tidbits that I find to be very interesting. She's talking about the case of Neha Gupta. We covered this, by the way, on the weekly roundup. So check out this week's weekly roundup, which came out yesterday. And I actually talk about this exact question, Faye. So I'm reading your mind before I even got to your question. So how on earth was she not charged with murder? Hold on. Sorry. How on earth was she not charged with murder, and could her mental health have played a role in that, is your question. And do you feel that she's being undercharged, and what will the jury do with that? All great questions. Here are the rough facts in this case. Neha Gupta is going through a very contentious divorce with her husband, which includes, of course, some sort of custody issue. She then, and I still don't think that they've explained it to us, she then goes on a trip. She lives in Oklahoma, I believe. She goes on a trip down to Florida, where this crime takes place, rents an Airbnb home there. While at the Airbnb, her young daughter, according to her, gets out. Is that the home? I didn't even realize that. Gets out of her room, wanders over to the pool, and according to her, falls into the pool and drowns to death before Neha is able to realize it or get to her. Medical examiner does an autopsy. These are the findings: no water in her lungs or stomach, and bruising to her mouth and cheeks that is consistent with being smothered. So now you have forensic medical evidence from the medical examiner that appears as though the child had been killed before going into the pool. You have motive evidence in the fact that she's going through this contentious divorce involving custody. You have the fact that she's away at a home with, oh, by the way, the husband, or soon-to-be ex-husband, didn't know that she had taken the child to this rented home. There's a pool in the home. again, all of these things seem to indicate murder, premeditation, motive, means, opportunity, right? So why in the world, when this was first charged as first-degree murder, are they now charging it as aggravated manslaughter? The difference between murder and manslaughter is really a difference in degree of intent, more than anything. It is what was manslaughter says that it's absent some sort of malice aforethought. That's where we hear about heat of passion. Was this something that she decided in the moment? Okay. Now, all of this being said, I think the first thing we always need to remember in these cases is we don't know all the facts. I don't know all the facts available to the prosecution. She's there in a what we call a suicide suit. So there's perhaps some sort of mental health issues at play. Maybe that played a role in the whole thing. But just generally, my thought on this is, I don't know if this is going to prove to be true or not, but my thought on this is I at least appreciate prosecutors exercising discretion. Prosecutors are gatekeepers. Defense attorneys are not. Defense attorneys have one job, and that's full speed ahead to defend their client. They don't sit down and go, I don't know how much I want to defend this client. This client sounds like a really bad guy. Maybe I'll give him a 80% of my effort defense. It is 100% all in defending that client. Prosecution doesn't operate the same way. It is not 100% full steam ahead. What is the most severe charge we can possibly prosecute this person with? Now, they should be aggressive. They should be creative in their thinking. They should be thinking about what are possible crimes that can be charged here. But I think we all appreciate prosecutors who use discretion. How many times have we seen recently where we feel like prosecutors are overcharging someone, being overly aggressive, charging stuff that maybe technically might satisfy the facts of the case, but are just too much for what we know to be justice in that case? Prosecutors shouldn't be asking themselves the question of what can I get, but it should be the question of what is justice. Now, that all being said, I don't know if that's true here. I don't know if this is first-degree premeditated murder, and if it is, that's what they should have charged. But it could be that they see other circumstances, other evidence that have pointed them in a direction where they might feel that though they could prove first-degree murder, maybe if they really went after it, what it more appropriately is a manslaughter case. She's facing 30 years on manslaughter. That is not a small amount of time. So maybe they feel in this case that this is more the pursuit of quote unquote justice rather than the pursuit of the most that we can possibly get. Again, Faye, I love that you asked the question. It's a heartbreaking case to me. She could either be an absolute sociopathic monster, or it could be something else that we don't quite know. And I think time will tell, and we'll continue to follow this case. But that was just kind of my thought on it, is it was just a little bit refreshing to kind of see prosecutors pump the brakes rather than what we usually see. Just a picky girl says, this case is so sad, that poor baby girl. I couldn't agree with you more. But these ones involving kids in the middle of divorces just absolutely tear me apart. All right, let's keep it going here.
Hey, Josh, this is Sarah from Tacoma, Washington. My question is regarding the Madeline Soto case. It might be a little bit of old news now, but there was a lot of heat when Kohberger took the plea deal because I guess the logic with the community was we wouldn't get to know the whys. We wouldn't know where the murder weapon was, etc. I personally don't think we would have gotten that information during trial, but either way, there was a lot of heat there. And my question is regarding Stephan Sterns. He essentially did the same thing, and I didn't see the same sentiments, I guess, happening there. And I'm just wondering why. Like, I don't necessarily want to know the details because that case is horrific and tragic and just terrible to even think about. But I'm just wondering where that same energy is. Why don't people want to know, was it an accident? Did something happen and he had to do it? Did Maddie fight back? Was there a struggle? Like, I want to know more about it because we really don't know more. And I'm just curious what your thoughts are. Is it because she's a minor? Is it because there's no Gonzalez family kind of, you know, making that narrative happen? What are your thoughts and what am I missing here? Because it's frustrating. I'm very passionate about it. Thanks.
Sarah from Tacoma, Washington. Let's put Tacoma on the map. I get it, Sarah. I totally understand your frustration. I totally sympathize. I don't think that any one case is, necessarily more important than another. It is funny how we kind of juxtapose these two cases because they did resolve within such a close time to each other. And it did seem like people were a little bit more outraged with the way that the Bryan Kohberger plea went down as opposed to the way that the Stephan Sterns case went down. And I agree with you that we want answers on that case as well. We want to know the why and what happened and what caused it and everything else. I guess just thinking about this, I think the natural kind of response that you see from most people on this is that when it comes to this horrible case with Maddie Soto, we heard about the conduct, we heard about the abuse, we heard about what was on his phone, we heard about how ongoing and systematic this all was, and we can kind of draw horrific conclusions, and we can kind of imagine in our heads why she met her end and what that was all about. Now, we don't know, what in those final moments actually caused it. And you're absolutely right. And we should want to know, and we should want to get those answers. But I think the reason why you saw so much more kind of outrage, and that's probably a good way of putting it, curiosity, outrage, frustration with the Bryan Kohberger case is because it was far less straightforward as to what was the circumstances leading up to this. There's so much more unknown and mystery surrounding all of this. What is the connection between him and these four beautiful people? We still don't know. Kaylee, Madison, Xana, and Ethan. We still don't know what put them on his radar, or if they even were on his radar, or if it was the house and they just happened to live at this unlucky home that he felt like was a good spot. We don't know any of that. The police to this day, and I know a lot of people, his internet passively connected to a restaurant where the girls used to work. I mean, we're grasping at straws here if you're trying to say that that's the connection. I know even recently some evidence has come out that perhaps he knew one of their names. Again, more mystery rather than answers, in my view. What was his connection to them? Who was the target? What did he intend to do when he went in that home? All of that stuff. What turned him? How about him himself? What turned him into this monster? Just recently, there were reports about the phone calls how many frequent phone calls he would have with his mother and father. He was incredibly close to them. Is that the telltale signs of a sociopath in the making? I don't think so. I'm no psychologist, but we're not hearing about the abuse of animals and bedwetting that we usually hear about. What created this monster in him? I think all of that starts to make us a little more frustrated, naturally so. But your point is not lost, Sarah, in that this case, Maddie Soto's case, deserves just as much inquiry and just as much questioning. But thank you so much for bringing that up. I appreciate you. All right, let's keep it rolling along here. You guys having fun so far? You enjoying yourselves? I hope so.
Good morning, Courtroom Confidential. Alicia from Upper Michigan, calling to see if you've ever heard about the Kelly Cochran case. That happened in my hometown. She and her husband made a pact when they got married that if one cheated, they had to kill who they cheated with. Well, they ended up killing a man that Kelly had cheated with, and they dismembered him, a little graphic, but they essentially fed him to the neighbors, parts of him. And then they were being investigated and they left town. And she, Kelly, killed her husband then in return. And now it is coming out that they have possibly killed up to 23 people. I was just wondering if you've heard about this case and if you have any thoughts on it.
Alicia from Upper Michigan. Thanks for the nightmare sauce for the week. I appreciate you asking this question, putting Upper Michigan on the map. Boy, oh boy. No, I was not aware of this case. It's funny. When I brought this case up, though, Tiffany goes, "Oh, I know that one." So it's definitely on people's radar, and enough that they actually did a documentary series on this. So if you guys want to learn more about it, I'm going to give you like the cliffest of cliff notes here. But there's a documentary series called "Love You to Death: The Kelly Cochran Story." It's playing on Fox Nation. I think it's also available on a few other spots. It's 6 parts long. If you make a 6-part docuseries, there's a lot of story to tell. But here's it in the most nutshell of nutshells. Kelly Cochran is married to a man named Jason Cochran. And she lands on police radar because she's connected to a man by the name of Christopher Reagan. Christopher Reagan goes missing in 2014. It turns out the police unraveled that Chris and Kelly had been having an affair. They perform a search warrant on the Cochran home, the home of Kelly and Jason, and they discover blood spatter throughout the house. By the way, just the smallest of issues. Just so you know, when they're talking about droplets of blood that you find on the wall, it's blood spatter, not blood splatter, which this article I read talked about, but the technical term for it is spatter. It's not like you splatter something, even though that is a thing you do. When you're talking about blood evidence, it's called blood spatter. Anyway, just a little pet peeve of mine, and something that you can bore all your friends about at cocktail parties, that you know the difference. Anyhow, moving on. They find blood spatter on the wall. They also find a journal, apparently, that had been kept by Jason Cochran that seemed to implicate that they may have been up to something. But they're on the run at the time that the search warrant is performed. The evidence turns out that, yes, it looks like they had disposed of his body. Yes, I was just reading up on this as much as I can. There was evidence of some sort of barbecue taking place within close proximity of him disappearing, where a lot of meat had been served to neighbors. I don't know if those dots are connected at all, but that did come up to Alicia's point. Anyhow, 2 years they're on the run. They eventually catch up to Kelly. And in the meantime, Jason also dies. Coroner's report comes out that he dies of asphyxiation. So now they believe that Kelly is good for Jason's murder and Christopher Reagan's murder. And they do these series of interviews with her where she's playing kind of cat and mouse, lie, truth, lie, truth. Eventually, it comes out that she admits that on their wedding night, Kelly and Jason had a pact. And that was that if either spouse cheated, I love how this pact doesn't begin with, how about let's not cheat on each other? The pact was, if either one of us cheat, then the cheating spouse either has to kill their lover. That's the way they'll solve that and make the world right. Or they will be killed by the other spouse. So this was their sick love story. And it sounds like they lived it out. And it sounds like that's exactly what was the motivation for killing poor Christopher Reagan. And then, I don't know, I guess Kelly somewhere along the line decided that there she is. I mean, just who sits like that in a police interrogation? But if you're just a very smug sociopath, she decided to kill her husband, Jason, somewhere along the lines. Maybe he refused to kill his lover, and so she had to follow through on the pact. Anyhow, a case I don't know a whole bunch about. I'm very appreciative, Alicia, that you put it out there for me to look into, and I'm going to watch that series. Love You to Death. It's just amazing to me, the romance of these people, real makings of a Shakespearean play, if you think about it. Anyhow, good stuff. Thanks so much. Let's keep it rolling. Where are we headed to next here? All right.
Hi, Josh. This is Leslie in Nashville, Tennessee. Quick question about Wendi Adelson and her testimony that will be upcoming in Donna's trial. I know she has derivative use immunity and some other kind of immunity. So basically, anything she says while on the stand cannot be used against her. My question is, what if she were just to say, yes, I drove by, I did, I knew all about it, and just admitted to everything? Then does that mean they could never prosecute her because she admitted it while she was on the stand? I know that's very unlikely to happen. I'm just kind of curious. Look forward to meeting y'all at CrimeCon. I will be there. Have a great week. Thanks for everything.
Leslie from Nashville, Tennessee. What a great question. Nashville, Tennessee, which was the location of last year's CrimeCon. I don't know if you were there, Leslie, but you're going to be at this year's CrimeCon in Denver. Please make sure you come say hi. We're going to have a booth. And I encourage everybody, if you're able to, make it out to Denver, September 5th through 7th. And there's a discount code for you. If you haven't purchased your tickets already, we've got you covered. Put it in the word courtroom, all caps, all one word, and you can get 10% off at checkout. So love to see you there, Leslie. Please make sure you come say hi at our little Courtroom Confidential booth. We'll be in the back, but you can find us. Just, I don't know, look for somebody screaming what's happening here. Great question though about Wendy's immunity. I'm glad you asked this because I think immunity is one of those things that confuses people a lot of times. First of all, in her case, immunity is not being used as if it's a gift to her. She doesn't want to testify. Wendi doesn't want to have anything to do with this. She doesn't want to see the inside of a courtroom. She doesn't want to be sitting in front of prosecutors. She doesn't want to be answering questions. And in fact, she usually would have a reason to stop all of that. And that would be her Fifth Amendment rights. She could say, I believe you're investigating me. I believe you think I'm a suspect. I think you think I'm implicated in all of this. And therefore, I have a Fifth Amendment right not to talk to you, not to testify, and to keep my mouth shut. So the way the prosecutors are handling that is saying, okay, well, we're going to take care of all of that. And we're going to grant you use immunity. Meaning anything that you say while on the stand under oath can't be used against you. Therefore, you don't have a Fifth Amendment issue at play, and therefore we can compel you to testify. So it's not for her benefit. She doesn't want it. Believe me, if she could reject it, she would. But she's been granted it and therefore forced and compelled to come testify. Now, the question becomes, what if, well, that means if she can't have anything used against her, that she testifies to, can she say stuff and therefore immunize herself from prosecution? What if she says, yeah, I was in on the whole thing? What if she says, I knew exactly why I was driving by the house that day? What if she says, I knew everybody was planning it and I was telling them to go ahead and do it? Does that mean she can never be prosecuted? Well, that's the difference between use immunity, which she's been granted, and transactional immunity. Transactional immunity says we cannot prosecute you for this crime. We feel that your testimony is so important that we will never prosecute you for the crime of X, the crime of murder. That's not what she's being granted here. And that is incredibly rare, almost never given. What she's been given is what's called use immunity or derivative use immunity. It's the same thing. What it means is we cannot use what you say in court under oath, nor can we use something derived from that, meaning you tell us something we didn't know, and then we learn something else from that. What it doesn't protect you from is independent sources. If we have other evidence on you, we can prosecute you. So you could get up there and say, I was in on the murder. And we can't use the words out of your mouth to prosecute you. But if we've got you caught on videotape, or we've got other eyewitnesses, or we've got an email train or a text chain or whatever else to tie you to this, we can for sure prosecute you for it. We just can't use what you said in testimony to prosecute you for it. So that's the difference before it. She's not being clever here. She's not getting an advantage. She's not protecting herself. And in fact, it's the last place she wants to be. She's being forced to be there because she's important to the prosecution and they want her to testify to certain things. But believe me, if they want to prosecute her, they're not limiting themselves. Excellent question, Leslie. Appreciate you asking it. And appreciate you bringing up CrimeCon. Please come by and say hi. All right. How are we doing? We enjoying ourselves? Talking about Donna, talking about the Cochrans. Oh, and I'll blow my mind for a while. Neha Gupta. We've covered a lot of territory so far. And now I lost my place. No, I didn't. Here we go.
Hello, Courtroom Confidential. This is Sonia from Chicago. And I have, an interesting question. So thank you for all the birthday wishes. Everybody was so sweet. But I did go out with my brother and my nephew and my niece. And I found out that my niece is going to be a dentist. And then my little nephew, who's also my godson, looks up at me. He's not little, he's 14. And he looks up at me with these big blue eyes and he goes, I'm going to be a prosecutor. And I was like, what? Man, I'm going to come to every trial. Anyway, so what happens one day when your beautiful daughter looks at you and says, Dad, I want to be a prosecutor? What do you say to a 14-year-old who wants to be a prosecutor? What would you say? Anyway, I'm really interested to hear your response. And he's perfectly capable of being an awesome one. I kind of think of him as a Matt Murphy, a young Matt Murphy. But anyway, all right. Thank you. Bye.
Sonia, love this question. Sonia from Chicago, Illinois. Let's put Chicago back on the map. First of all, if a 14-year-old said to me, I want to become a prosecutor, I would be fully impressed and say, how do you even know what a prosecutor was? I don't think I learned what a prosecutor was until I was in law school. So good on that 14-year-old for being so educated and aware. What if my girl said to me at 14 years old that she wanted to become a prosecutor? I think I'd be thrilled. I think there's, it's a very noble calling. It's public service. You really have to be at the height of your game. It was a job that I thoroughly enjoyed. Probably a career I would have kept for the rest of my life. If it wasn't government work, if it meant that I could do and pursue other things and get paid a little bit better, I'd probably still be doing it. But I applaud anyone who wants to go into any kind of public service, and especially being a prosecutor was one of the great joys and prides of my life. I will also say, though, it's a really tough job. It's a very, you're going to deal with a lot of, Malibu Table Maven says, yay, prosecutors. You're going to deal with a lot of ugliness. You're going to see a lot of the bad side of life. I think it's a real education as far as the real world that we live in. You're gonna deal with a lot of emotional trauma you're going to have to go through a lot of emotional I mean, it is, there's stuff that, you know, I still have a hard time thinking about, of things that I had to deal with and go through, and ugliness that you got to see. I will say this though. When I first was exposed to the prosecutor's office, to the DA's office, I didn't want to be a DA. I thought of prosecutors as being, I don't know, like failed attorneys, like they couldn't make it somewhere else. So they kind of fell into this, like they were the mail carriers of the legal world or something. I don't know. No offense to mail carriers either. I don't know what I thought of the whole thing. I just didn't think of it as being all that glamorous. And I, from day one, being a law clerk, had that notion, was disabused of that notion. The prosecutors I worked with were all young, hungry, brilliant, fun lawyers who were very, very, very good. And it was also kind of like going to college again. It was just a very fun environment. And I'm still very close friends with a lot of those people. So tell your nephew to call me for a letter of recommendation. And I hope that one of my girls decides to pursue something like that one day. One day, very long from now, because they're not allowed to grow up so fast. Thank you, Sonia. Bluebird says, speaking of immunity, Stephan Sterns pled guilty. Would this remove any immunity deals the state had made with Jennifer Soto? Do you see the state charging her in the future? The answer to that is it really depends on the immunity deal. If the immunity deal was only for her testimony during that trial, then yes, it ends. They can structure it however they want it. It could be, you get immunity for this day. You get immunity for this testimony, for this prosecution. And they could end that. And it goes back to the same thing we were talking about. It really depends on what the immunity only goes towards the words out of her own mouth. In other words, if somebody says, I did it, you can't play that videotape in court. You can't call the officer to say that person admitted to me they did it. But if you have other evidence pointing to that person, you can for sure use that when you're talking about use immunity. You're just not using their own words against them. So thank you, Bluebird, for the super chat. Appreciate you. All right. Ooh. Why do I feel out of breath? All right, let's keep it rolling here.
Hi, Josh and CC fam. This is Steemac calling from Alexandria, Virginia. I really enjoyed Kevin Fixler's update on Monday, but I wasn't able to join it live and ask questions, and I'm left with a couple of questions. My first one is there any chance that federal charges will be brought because BK crossed state lines, and that would offer the opportunity for a federal death penalty case? And my last one is it's a little touchy. There's a lot of speculation online that the sheath may have fallen off when he undid a belt, which is a horrible thought. But that K-bar sheath is designed to be worn on a belt, and it's kind of hard to imagine that he would have gone in there with it in hand. So is there any indication from the surviving roommate's very accurate and detailed description that he may have been wearing a belt? Did she describe his clothing at all? And that's it. Thanks a lot. Bye.
Sneemac calling in from Alexandria, Virginia. Let's put that on the map. Great question as always, Sneemac. Always love hearing from you. Talking about Bryan Kohberger and the Idaho 4 case. And can federal charges be brought against him because he crossed state lines? There they are. Look at those beautiful kids. It is so haunting to me that this photograph was taken just before they lost their lives. If you don't tell me that there wasn't some sort of, I don't know. I don't want to get into it. I just think it's incredibly touching that they all, for one last time, got together for this photograph. Anyhow, can he be prosecuted federally because he crossed state lines? There's two answers to this one question. One, he can be prosecuted federally, but not because he crossed state lines. Because we've talked about this before, this idea of dual sovereignty in the United States. There's the federal government, which covers the entire federal territory of the United States. And then each state has their own state government. Each state has their own penal code. Each state has their own prosecutors. Each state has their own judicial system. But so do we on the federal level. And sometimes there's some overlap. Sometimes you can commit a crime that is both a state crime, according to the penal code of that state, the state of Idaho. They have a crime called murder on the books. And the feds have a crime called murder on the books. So you've committed that crime in both sovereignties. The vast majority of the time, the feds don't get involved in these types of things because they let the state handle it. The state handles most of the crimes in their state. The feds get involved when the states can't get involved. When it is something like some sort of interstate commerce is involved, crossing of state lines, perhaps it's a wire fraud sort of deal that is a federal crime, dealing with banks. Usually, when you have a bank robbery, usually you're dealing with a federal crime. They get involved in stuff like that. But does not mean they're excluded from prosecuting somebody for these other things, including murder. So sometimes you will have murder cases that are handled by the feds. Sometimes you'll have both the feds and the state going after somebody for a murder, i.e. Luigi Mangione. But that is incredibly rare. So they could prosecute him here. They're not going to prosecute him here. But it has nothing to do with whether or not he crossed state lines. It has to do with the fact that murder is against the federal law of the United States. Now, there could have been a reason where if he committed crimes in Washington and then committed murders in Washington and then in Idaho or whatever, that maybe the feds would have felt it more appropriate for them to get involved rather than having two states dealing with the same kind of series of crimes. Somebody commits serial murder over state lines. It's easier for the Fed to get involved than to have all these states coordinate with each other. But that's really not the issue here. The feds have let the state of Idaho handle their own business, and that's the way it's going to remain. This next part of your question, I thought was very, very interesting. I had not heard this theory before. I had always wondered, why was it that he carried the knife in a sheath when a sheath, its entire purpose is to be worn on the belt? That's the purpose for it, is so that you don't have to be holding it. You can put it into your sheath, which is tied to your belt, so that you can, when you're not, I'm not talking about like in the course of murdering people, but I'm talking about like you're out camping and you need a knife. There's your knife easily accessible. And you can see here on the sheath that there is a belt loop. So why wasn't he wearing it on his belt? What a great question. And then your question is, well, then does that indicate that perhaps he removed his belt to remove the sheath? I'm wondering, though, Sneemac, and again, we're all just speculating because we don't have these answers because nobody asked him, but I'm wondering, though, if given the nature of that belt loop, if he didn't want to put it on his belt because it cannot be easily removed. In other words, to remove that sheath, he would have to take off his belt completely to take it off. And maybe he's thinking to himself, I'm going to go in here and stab this person or persons. Then I'm going to get into my vehicle and I'm going to dispose of all evidence of it quickly. And I don't want that to include me having to remove my belt just to get the sheath off. I mean, the last thing he would want is to get into his car, ditch all his clothes, throw out the knife, get pulled over by police. And they want to know, why does he have a knife sheath still on his belt? I don't know. Again, a thing that we don't know about. We don't have, I mean, here's another great point. Joy W. Can says, if he was wearing coveralls, they don't have a place for a knife, for a belt, for him to even loop it on there. All this stuff we don't know. We don't know if he was wearing coveralls. The most we know is he was dressed all in black. His face was covered. We know a knife sheath that was recovered. Why he was perhaps carrying that. I mean, the other reason he could be carrying it in the knife sheath is that, carrying around an open blade. This is a fixed blade, not a blade that can be folded away. So perhaps he just out of protecting the blade while he's sneaking into the house, he has it inside of the sheath. And then in the middle of these murders, he just drops it. Great question, though, Sneemac. It's something I had not thought about. Yes, I think that there is. I know that some people have been looking into the evidence that perhaps he had other intentions when he entered that home. But again, we don't know. But thank you for asking. True Crime in a Minute says, and thank you so much for the super chat. Thanks for the awesome immunity answer about Wendi. See you in Denver. My first crime con, Leslie in Nashville. You're going to love it. You're going to absolutely love it. My first crime con was in Nashville, and it blew me away. It's wild. Southern CJB, thank you so much, says, I so want Josh's thoughts on Nicholas Kassotis' defense. What a wild ride that was. I am so surprised no one has asked. Someone does ask. Buckle up, because I think it's coming up here in a couple of questions. We're going to talk about Kassotis, but thank you for previewing that for us. All right. Where am I at here? Oops.
Hi, Josh. My name's Jeanette. My YouTube handle is Jersey Jen. I live in Lyndhurst, New Jersey. First, I just want to say I love this channel, and I've learned so much from you. I wanted to ask your opinion about bail reform laws. And I'm not asking this from a political standpoint, but rather to get the opinion and perspective from someone like you who's been a criminal defense attorney as well as a prosecutor, and seeing this on both sides of the aisle. Just to give you a little bit of background why I ask is I'm a domestic violence survivor, and unfortunately I've been exposed through my experience to our criminal justice system and some of the obstacles we face here in New Jersey, as well as some other states where there are bail reform laws. I understand the theory behind it. I believe it was enacted in 2017, and the purpose is to keep the community safe. And I understand that, but from my experience and what I continue to see throughout our country with different cases, this hasn't been. For example, I've been following the Logan Frederico case. Young girl, 22 years old, same age as my daughter.
Jeanette from Lyndhurst, New Jersey. So sorry that you got cut off at the end there. But I love your question, and I want to answer it as best I can. And I think I got the gist of it from what you were asking. So let's put Lyndhurst, New Jersey on the map, first of all. I want to talk about the case that you mentioned toward the end first. You talk about the Logan Frederico case. This is the case that, again, I was not all that familiar with, and another really tragic case. There she is, 22 years old, beautiful, beautiful girl. Her father is named Stephan Federico, who's been incredibly vocal. I mean, I just can't imagine what this man is going through. I just can't imagine having your heart ripped out of your chest and then still having to walk around and put on clothes and brush your hair as a human being and put one foot in front of the other. But he is many times what we see with these people, just remarkable in his strength, and has tried to turn this into, tried to make something of this and make something of value come out of the tragedy and nightmare of her death. And he is focused on the idea of the man who took her life was a man by the name of Alexander Dickey, who has a rap sheet about as long as you want to imagine. He had 40 prior arrests, which included 25 felonies. And many of these were for residential burglaries, for home invasions. And what has happened to Logan was in Wexham, North Carolina, in May 2025. So just earlier this year, Alexander breaks into her home to steal a bunch of credit cards and ends up shooting Logan in her head What we're starting to find out is that that looks more and more like it was an execution. She was unclothed to some extent. She was apparently on her knees at the time and shot in the back and the head. Execution. Whether that was to cover his tracks, whether that was because she stopped him, whatever it was. Now we've gone from, a bunch of kind of residential burglary nonsense into capital murder. And to make this even worse, not only had he had this extensive felony rap sheet, but in 2014, for another residential burglary, instead of being given prison, he was given probation and put on 10 years suspended, meaning if he had any kind of violation of that probation, the suspended time would be executed, would be put into effect, and he should have gone to prison for 10 years for anything that he did after that point. Well, in 2023, he's arrested again for a resburg, but because of, and again, this is where I wasn't able to get to the bottom of it, apparently issues with the prints that they took of him or whatever it was, they don't realize his prior plea. They don't realize that he's got 10 years suspended, and they give him probation again. So where Stephan Sterns has really made the heart of his campaign has been about this man never should have been out of prison anyways. This person's a violent criminal, demonstrated about as much as you can demonstrate that he shouldn't be a part of law-abiding society. And in fact, a person who should have been in prison was out committing another crime and took the life of his daughter. That all is, I think, without argument, a tragedy. The guy deserved his time in prison and should have been in prison for a very, very long time. I don't know where in the 25 felonies he's still getting. I mean, I've been a part of the system and I've seen people continue to commit crimes and I've seen them in and out of the system. I don't know if I've ever seen something like this. 25 felonies later, including residential burglaries, and the guy's still walking around on probation. But to your question, Jeanette, this is a little bit different. This isn't really about bail reform. This is about sentencing. And this is about prosecutors doing the right thing and about perhaps, changing laws to make them a little more straightforward about making sure people serve their prison time. And about making sure that there's proper vetting, understanding a person's criminal history when they're given a plea deal. The fact that there was some oversight that they didn't know his criminal history when they offered him this new plea deal or gave him probation just blows my mind. Bail reform, though, is a different question. And it's still a very good question and a question I'm happy to weigh in on. Bail, though, so we all are talking about the same thing. Bail is talking about before the conviction. And maybe that was a part of it. Maybe he was out on bail during this time too. I didn't read that. And if I'm wrong, forgive me and somebody correct me. But bail is talking about the imposition or the obligations or what we're doing to ensure that about how we're handling someone before they've been convicted. Somebody's been arrested and they're only accused of a crime. They're presumed innocent. Now, what do we do with them? Well, there's two primary concerns that the judicial system has. Public safety. So if you committed a crime of violence and you've been arrested for that, what are we going to do about making sure that we protect the public? And two, guaranteeing you return to court. Thank you so much, Surviving the Survivor, for the membership. Appreciate you guys. What do we do about ensuring that that person returns to court? We've got public safety, returning to court. What is the best mechanism to make that happen? Well, think about it. How do you do that? What way do you compel people to behave themselves and come back to court? Because your alternatives is just lock everybody up or let everybody go, right? You could say, well, for certain crimes, you get locked up. Okay, fine. Crimes of violence. So you're saying anybody and everybody accused of a crime of violence stays in prison until their trial? The whole system would be full of people. Or do you say, okay, well, then everybody gets out? Now you've got everybody out. So there has to be some sort of balancing here. And the best way that we've come up with, and it's hard to find a different way, is money. We say, okay, well, we know one thing that across the board people care about is money. And if we put bail on them, that will ensure that, one, they have a reason to show back up, because if they don't show back up, then they lose a lot of money. And if we make that bail high enough, we make sure that the people who are able to post it are probably going to behave themselves, because there's this compelling reason behind it. I already hear your argument saying, well, that sounds a little ridiculous, but the alternative does come down to, what else are we going to do? Okay. Now, in modern times, more recently, and I mean within the last 10 years or so, we've done things like ankle monitoring and home arrest, and there are other creative things, and a lot of jurisdictions are pursuing that. But I think ultimately, in the question of bail reform, where you have these legislators making laws where they're saying these types of things you can't keep a person in for, and those types of things you have to lock a person up for, I have a major problem. And I never think it is a good idea when legislatures take discretion out of the hands of prosecutors. I don't feel comfortable with the idea of somebody sitting in the state capitol who's never spent a day in court deciding, because they've got a bunch of ideas, what's the best way to handle bail, rather than putting it in the hands of the people in court every day dealing with this stuff. You can say, here are guidelines. You can say, here are I think that, this is the way we want our society moving towards. And we are doing that. But when you start to take the discretion away and make absolute rules, it leads to disaster, because those people aren't living the day-to-day of it. That is my soapbox for the day. That's the next graphic you have to come up with, Kaylin, is Josh's soapbox for the day. Anyhow, great question, Jeanette. Interesting topic. It is something that is obviously hotly debated. And I think it's important to think about. Thank you so much. All right. Gina Gilmore, thank you so much, says Israel Keyes read and studied Mine Hunters by John Douglas. Oh, interesting. Also a very interesting book. Thank you for that, Gina. All right. Where am I at here? Okay.
Hello, Josh and CC crew. This is Momo calling again from Portland, Oregon. And I have a question about the absolutely wild Nicholas Kassotis case. He took the stand today, and that was crazy. But so the prosecution on one of their questions. So, man, if you don't know about this case, there's a whole made up character from the defendant. And the guy's name is Jim McIntyre. And like, most of us are pretty sure this man does not exist. But basically, the prosecutor asked him if he had subpoenaed Jim McIntyre or used like a PI to search for him at all in anticipation of this trial. And I was just kind of wondering, like, the PI one might kind of be on the fence of like asking him about his own personal curiosity, but like specifically asking if he tried to subpoena a person for the case that she's questioning him in. Is that not kind of like burden shifting? I mean, the defense attorney didn't object, which maybe means it's not burden shifting, or maybe it was like strategic or what, but that just kind of occurred to me, and I was hoping you could shed a little light on that. So thank you.
Momo from Portland, Oregon. I love this. What a great question. We have the smartest community in all of true crime YouTube, in my opinion. Grizzly True Crime says, oh no, not Jim McIntyre. Oh yes, Jim McIntyre. I love this question because I can't imagine, I don't know what your background is, Momo, or what line of work you're in, but I just love that you're asking a question about burden shifting. I can almost guarantee you that 9 out of 10 people who aren't in this community have no idea what you're talking about when you're talking about burden shifting. And I think it's such a insightful question. And it's like a law school type question. It is an interesting issue. You've got the defense here who has no burden, never assumes a burden, but you get the question of, why didn't you subpoena someone? Does that shift the burden? Does that make them have to show that they did something and somehow prove something to the jury that they don't otherwise have to prove? Love it, love it, love it, love it. And again, this is our Nicholas Kassotis question. Somebody was asking about that earlier. It is a wild case. If you guys haven't followed it thoroughly, he was just recently convicted, though. Spoiler alert. But he had this wild theory that this guy, Jim McIntyre, Nicholas Kassotis has now been convicted for murdering his wife, Wendi Kassotis, dismembering her. Her body was found over a 3-mile radius. And he says that Jim McIntyre, who maybe was or was not an FBI agent, who was warning them about threats from mysterious figures that were coming after them, and he's a mysterious figure. And he's really the person behind all of this. And it was just, to Momo's point, wild. And the prosecutor says, well, where's Jim? Did you go subpoena Jim? You send out an investigator to go find Jim? Because Jim doesn't exist, ladies and gentlemen. Anyhow, great question. The answer is, did that shift the burden? The question is, did that shift the burden? The answer is, I don't quite know, but you know what? I've got friends. So you can stump me, but you can't stop me.
Sorry to do this from the car, but I just finished a rollout and I wanted to answer this question for my friend Josh. So the issue is whether the prosecution can point out a failure to call logical witnesses. There's actually a legal doctrine called a failure to call logical witnesses. And what that means is the prosecution, although in general the prosecution cannot do what is called burden shifting. In other words, shifting the burden of proof to the defense, because we have to prove our case beyond a reasonable doubt. And we're the ones who have to since we brought the charges, we have to bring up and prove the case. However, if the defense brings up a witness or starts questioning a prosecution witness about potential defense witnesses and they fail to call that witness, we can do what is called a failure to call logical witnesses. In other words, point out to the jury that the defense had the power of subpoena, that they could have proven this fact with that witness, but they failed to do so.
That, ladies and gentlemen, is my very, very good friend, Eric Sedal. He's a prosecutor in the DA's office. He still is a prosecutor. We were in many of the same assignments together. I've known him for, God, a long time, going on 15-something years. And he's one of my very good friends. And he's also a brilliant lawyer. And he's usually the guy, when you guys ask me questions and I don't know the answer, I'm usually bugging him to give me the answer. And he is in a unit in the DA's office called COPOS, which is for crimes against police officers, which is one of the most elite units you can be in. It handles a lot of murder cases, a lot of death penalty type cases. And he is, what he's saying right here is, he's apologizing for being in the car because he was on a rollout. When you're in COPOS, one of the things you do is you go on rollouts, meaning you get called. There was an officer involved shooting in Pacoima at 2:00 in the morning. If you live in Southern California, that joke makes more sense to you. And you got to drive out to Pacoima to be there for the investigation. Why was the gun used? Were the officers shot at? All of this type of stuff. So he was in the middle of that when I called him and said, I need you to answer that question. And he said, but I'm in my car. I said, I don't care, man. I got deadlines. Tomorrow's Sunday. I need an answer to this. So he was kind enough to give us an answer. Eric Sedal, a good friend of mine. And there's the answer to your question is yes. There's specifically a concept called failure to call logical witnesses. So the defense, it doesn't shift the burden, but if the defense doesn't do something reasonable and logical and they make it an issue themselves by perhaps, let's say, I don't know, talking about somebody named Jim McIntyre, who's the person behind behind the scenes pulling all the strings, you can ask, where's Jim? And you can turn to the jury and say, why didn't they subpoena Jim? Malibu Table Maven says, hi to Eric. He's a great prosecutor. He is an excellent prosecutor. And he's also a good friend, and I appreciate him answering that question. I hope that clears that up for you, Momo. No burden shifting. Use burden shifting throughout your conversations this week and explain to people about the failure to call logical witnesses. All right, let's keep it rolling. Don't yell at me, Kaylin. It's not my fault.
Hi, Josh. This is Pam from Michigan. I have a Donna Adelson question. Actually, it's more Wendi Adelson, the Donna Adelson trial. I saw on YouTube somewhere that Wendi Adelson was asking the judge to not let her be questioned by the defense. I was wondering a couple things. Is this because of her immunity deal? Does it not cover her immunity when the defense asks her questions? Is it something that could possibly lead to her being brought in and arrested for the next person for the trial? And is it something that even she's allowed to do? Like, can she actually ask the judge to not let her be questioned by the defense? You know, I know she can plead the fifth, but is that something that goes against her immunity deal? I'm wondering if all this ties in. Anyway, just thought I'd ask that question, another layer of the onion in the Donna Adelson trial, and hopefully Wendi does get to be the next person to have to go to trial. Fingers crossed. Thanks a lot. Have a great day. Thanks for everything that all you guys do. Really appreciate it. Bye.
Pam, you're so kind. You're so sweet. Thank you so much for the question. Pam calling from Michigan. Let's put you on the map there. Another great question. Talking about Donna Adelson's upcoming trial and Wendi Adelson's grant of immunity. And what is she talking about? She recently filed some paperwork where she's kind of objecting to the defense calling her as a witness. And again, a very perceptive question here. What is going on? So we talked about immunity. She has immunity from the prosecution. That is use immunity, meaning if she's called to the stand by the prosecution and she answers questions, nothing that she testifies to can be used against her. She doesn't have an immunity deal with the defense, and the defense can't grant her immunity. She's on the defense witness list. So Wendi's concern is, hey, I'm covered if I testify for the prosecution, but if the defense calls me, I don't have any coverage. I don't want the defense calling me. So she's asking the judge to essentially quash the subpoena from the defense for her testimony. So what's going to happen here? Well, it raises a few interesting questions. One, the defense has a right to call witnesses. They cannot be precluded from calling a witness just because that witness has been called by the prosecution. In other words, prosecution can call a witness. They can ask them certain questions. The defense can cross-examine on those questions. But if the defense wants to call that witness for another purpose or to ask them different questions outside of the scope, they got to call them themselves. And that does happen sometimes. They're not allowed to take that prosecution witness and start asking them a bunch of unrelated things that might be important to the defense because it's outside of the scope of the direct examination by the prosecution. That's concept number one. Concept number two is she's got a Fifth Amendment right. Now, she doesn't have it for the prosecution because they've granted her immunity, but she does have it for the defense. So now she could make herself an unavailable witness to the defense if she claims, I'm claiming the Fifth when you subpoena me. What issue does that cause in that she has been a witness, she has been available to the prosecution, but now she's prevented from being a witness for the defense? How is this all going to work out? The defense is asking that Wendy's attorneys are asking that the defense be precluded from calling her as a witness. I don't see that being the resolution to this. What I do see is this Judge Everett, who we all love. Maybe he's the guy I should interview. I'll put him on my potential interview list. Love him. I think he is very smart, and I think he's very reasonable. And I think what he'll say is she will have the immunity granted to her by the prosecution, and that I will allow the defense to have wide latitude in their cross-examination of her so that they can get into the issues that they might want on their direct examination of her, so that they're protecting the rights of Donna and her full exploration of her own trial strategies. But at the same time, there he is. He's saying, hey, Courtroom Confidential, I'd love to be a guest on your show. Just call me when I'm done with this trial. That they will allow for her to testify, not prevent the defense from exploring their full defense, and not worry about exposing Donna or Wendi to something outside of her scope of immunity. I think that's the kind of patched together tight wire act that's going to have to take place here, because I can't see another way of this resolving. It's an interesting issue. And it also makes me wonder about, what is she worried about being questioned by Donna's attorneys about? What possibly could they be questioning her that she feels like, I don't want to be answering those questions? Interesting stuff. It's going to be an interesting trial for sure. And we talked about it on the weekly roundup, by the way. If you haven't checked out the weekly roundup, already out and available for you on Courtroom Confidential. All right. Thank you, Pam. Grizzly True Crime says, been working, but also lurking. Happy Sunday Fun Day, everybody. Let me take you with on a jog in Switzerland. Oh, I want to see like a live stream of that. Can we make that happen? Sounds lovely. A jog in Switzerland with Gisela from Grizzly True Crime. Brought to you by Courtroom Confidential. All right. Let's keep it rolling here.
Hi, Joshua and crew. It's Julia DeNurse calling from Trenton, Ontario, Canada. And I'm calling about an interesting situation that has arisen. Josh had done a show regarding the teacher who had killed the two parents on the hiking trail. I think it was in Arkansas. And I had listened to the show later after it had been recorded, and I had made a comment in that comment section about researching Elizabeth Wetlaufer, who is a nurse in Ontario, Canada, who was a serial killer, and you'd be able to understand more about how that teacher was able to go state to state to state and still practice and have no repercussions. So interestingly, Annie Elise, who is another true crime person that has a podcast on YouTube, she came out with a show 2 days ago that was about Elizabeth Wetlaufer, the serial killer nurse in Ontario, Canada. I thought you might like to know that your show reaches out probably farther than you ever thought it did. I thought you might like to know that. Have a great day.
Julia from Trenton, Ontario, Canada. Thank you so much for the kind words. Thank you for being a part of the community and for asking great questions. Yeah, we had talked about the Andrew James McGann case, another tragic case. A mother and father, a husband and wife lost their lives just going out. This kind of stuff, people going out for a hike, just doing normal, nice stuff. Nice, taking their little girls out for a hike in Arkansas, and a psychopath runs across runs into them and stabs them both to death. And the story that we're starting to learn is that the mother there, who is a absolute hero, runs her little girls to safety, then comes back to try to help her husband, who's involved in a fight with this psycho, and she ends up losing her life as well. So he was apprehended, and he is now being prosecuted for murder, and it looks like it's going to be capital murder. And Julia had referenced the Elizabeth Wettlaufer case, which apparently then fell on the radar of Annie Elise, big time YouTuber. We're a fan of her channel, and she did an episode on Wettlaufer. She was a silent serial killer. She absolutely was. Great episode. Check it out. Tell her Courtroom Confidential sent you, and we say hello. She's another person I think would be a fantastic guest. And it got me thinking about the Wettlaufer case. So here's the cliffest of cliff versions on the Wettlaufer case. This was out of Canada, and between the years of 2007 to 2016, she was a registered nurse working with older folks, and she ended up killing 8 senior citizens by giving them insulin. I didn't even know if you would call it an insulin overdose, but if you inject a person with insulin who doesn't need it because they're not diabetic and suffering from some sort of diabetic attack at that time, you can cause a person to completely lose consciousness at best, and at worst, lose their life. And she did that 8 times and had attempted it many times more. In researching this, I invite you all to take a closer look at the case or watch Annie Elise's video. Again, tell her we say hi if you do. She talks about why was she doing this? You know, we've heard about these cases before where people take the lives of people under their care. Sometimes it has to do with they're frustrated. Sometimes it has to do with whatever. She said that she would experience these surges, she called them, and that they came from God or the devil or whatever wanted me to do it. And that after she would take someone's life, where these people are made, I have no idea. After she would take a person's life, she would hear laughing, and it was like the devil was laughing inside of her. So there you go. That is Elizabeth Wettlaufer. For more details, and there are plenty more, check out Annie Elise's episode on that and tell her we say hi. Shy Gal, thank you so much for the gift of memberships. Again, for gifting the membership. Oh, I love this. I love it. 3 in a row. Appreciate you, Sonia. And thank you, Best Nancy, for also joining in and gifting a membership. I love the gift of memberships because if there's anything we want to do, it's absolutely grow the membership community, because we try our best to make it something you guys are going to enjoy. And sneak preview, I've got a special announcement for our membership community at the end of this. So don't go anywhere. Stick around. We have our August members only giveaway, and I've got details on that. So stick around, everybody. All right, let's keep it rolling. Where are we at here? Ooh, we're coming down towards the end. All right.
Hello, Courtroom Confidential. This is Renee from Spokane, Washington. I have a question regarding the Adelsons. Is there a way for Charlie or Wendi to communicate with Donna through her attorneys? Can either of them let Donna know that they can't or won't testify at Donna's trial, or would any such communication violate privilege? Thank you for Sunday Fun Day.
Renee from Spokane, Washington. Thank you so much for calling in. Great question. Obviously, we're getting a lot of Donna Adelson, Wendi Adelson, Charlie Adelson questions coming up. Her trial is starting next week, Tuesday, the 19th. That's 2 days from now. Jury selection begins. We're expecting it to maybe take through the rest of the week, which means we might have opening statements as early as Thursday, Friday. I have a sneaking suspicion they'll probably take the week to do jury selection, then begin on Monday with opening statements, but we'll see. But wherever they're doing it and however they're doing it, we will be covering it over on Courtroom Confidential live trials. So make sure you tune into our sister channel, set your notifications, make sure you subscribe. It's always a great community to watch these trials live, and I'm glad that we have another trial to start up, and I will be peeking my head in every now and then to say hi. But your question, Renee, is can they communicate with each other through their attorneys? Short answer is yes, absolutely. Privilege or not privilege, you can always communicate through your attorney. And that's the whole point of having an attorney and having attorney-client privilege is it doesn't breach that privilege if the attorneys talk to each other. Now, attorneys talking to someone else can breach that privilege by mentioning something their client said. And that's why attorneys always have to be very careful about disclosing the substance of conversations they have with their clients. But attorneys talking to each other happens all the time. And can they communicate to her team that they don't want to testify? Not only can they, I'm sure they have. I'm sure it is no mystery to anyone that Wendi doesn't want to testify. But for the reasons we've already discussed, they're going to make her. The prosecution's going to make her testify. Charlie, on the other hand, I think it's funny. Florida has this weird kind of part of their practice where you kind of have to put anybody and everybody on a witness list just so people are aware of that and can litigate that. I'm used to, in California, we have to kind of say it's usually those you intend to call. It's not like you put an exhaustive list of everyone. You can, but I think Charlie's on that list just as a potential. I know that they've transported him because he's been subpoenaed. Is there a potential that he testifies? They have not granted him immunity, nor would they. And he's got a Fifth Amendment right because he's still got appeals. So I just don't see it happening. Maybe other people are saying differently and maybe I'm wrong, but I just don't see it happening with Charlie. But Wendi definitely, I believe, is going to testify. But as far as to your question, Renee, sure, they talk to each other. And I don't know how friendly they are with each other because it sounds like everybody's got their own camps at this point. All right, let's keep it rolling here. Oh, JC Broadway just became a member. Good to have you. Love it. Tammy Hawkins, thanks for the super chat, says, Josh, is it hard to be a defense attorney after your job putting people in jail for so long? Not because of that. I've talked about this before, but what is the word I'm looking for? The switch, oh God, I'm blanking on the word I'm looking for, but the kind of philosophical switch from prosecutor to defense was not nearly as hard as I thought it would be. In my brain as a prosecutor, I thought, how in the world could I ever do that? But in practice, you're being an attorney. You're representing the interests of your client, whether that be the people of the state or whether that be your individual client. And I will say, if you ask me, going from a prosecutor to a public defender, probably something I couldn't do. But as a private defense attorney where I get to pick and choose my clients, a little more easy. But yeah, I think good attorneys are not so dyed in the wool philosophically that they cannot be successful on both sides of the bench. Thank you for that, Tammy. All right. Oh, and thank you, Lori, for becoming a member. Appreciate it. You're gonna love it. We hope you enjoy it. All right. Here we go here.
Hi, my name is Heather. I live in Galt, G-A-L-T, California. It's in Northern California up near Sacramento. So in BK's case, evidently there's complaints that he can't sleep and he's being taunted in prison. And the Idaho prison system has come out and said something. And then, but could his parents intervene on his behalf and say, we want him moved to another prison, either in Idaho or move him to Pennsylvania?
Heather from Galt, California. Let's put that on the map. Here we are, up near Sacramento. You are correct in your geography. Yes, poor BK is being tormented in prison. And what can his parents do? Let me just say this. He is never leaving Idaho. Okay. I know people are, what his parents live in Pennsylvania. They don't care. He committed the crime in Idaho. The state of Idaho has sentenced this man. The state of Idaho wants their justice. And their justice is that this man remain in a prison in Idaho for the rest of his life. 2, Pennsylvania don't want him. They don't want to house him. They don't want to pay for him. They don't want to assign guards and a cell to this man. He didn't commit a crime in Pennsylvania. He committed a crime in Idaho. Doesn't matter where his parents live. That's not how it works. He's not going anywhere. But can they intervene because he's being, quote unquote, tormented? And the reports are coming out. This is some videotape that was shown of him in his cell. It's a freeze frame from that they're yelling at him through the vents, the other inmates, that, that they're making his life miserable. I'm not trying to dance on these cases here, but boo-hoo. Okay. Here's the thing. Prison's a bad place. Don't go. I don't recommend it. Prison is full of other prisoners who happen to have committed some really bad crimes themselves. By the way, he's being housed with a bunch of other people doing life and a bunch of people probably on death row as well. They're all bad dudes. They do not care about this man's feelings. And he's got an absolute target on his back. They don't like celebrity inmates taking all the headlines. They don't like guys who've killed children. And that's how these kids will be viewed to them. They don't like guys who've killed women. He is not in the hierarchy of badassery in prison. He's not that high up there. He is kind of the lowest of the low. I imagine his life is not going to be very pleasant in prison for a very long time. I will say, though, that looks like a rather large cell to me. I didn't realize that those cells were that big. He seems like he's got plenty of room to walk around, but he'll probably be spending 11 hours a day in there. 23 hours a day in there. Maybe more. Maybe he gets an hour of time outside of that cell, maybe twice a week or something like that. This is prison. These reports, and I know they're kind of reporting on everything that happens with Kohberger nowadays, but these reports that he's being, quote unquote, tormented in prison. He's in prison. It's not a fun place to be, and you're not amongst a bunch of poets and philosophers. It's a bad place to be. Don't murder 4 people. Thank you so much, Heather from Galt, California, for asking the question, though. All right, let's move it along here. We're down to the final 3, everybody. Don't go anywhere. Announcements and fun stuff coming up.
Good morning, Josh. Happy Sunday Fun Day. This is Carolyn from Highlands Ranch, Colorado. I have a question I'm hoping you can clarify. I am wondering why sometimes there is a preliminary hearing and other times there's a grand jury proceeding. I know in some cases, I'm thinking of the Barry Morphew case that will be coming up here. He was indicted by a grand jury. But in some other cases, I don't believe that's the case. I don't think they go through the grand jury process. And so I'm just wondering how the decision is made. Is it based on what the charges are, or do you think maybe it's based on county by county? Anyway, I'm hoping you can give me some insight on that and others insight on that. And looking forward to hearing your explanation. So thank you so much. And I'll be seeing you in a few weeks at CrimeCon. Thanks so much, Josh. Bye-bye.
Carolyn from Highlands Ranch, Colorado. I was waiting for that. I was about to say, you better come say hi to us at CrimeCon if you're in Highlands Ranch. That's right outside of Denver, right? Yeah, we'll be there in just a couple of weeks here. Oh my God, it's approaching so quickly. Great question, Carolyn. What's the difference between a prelim and a grand jury, and why do they use it sometimes and not others? And how does that work between jurisdictions and everything else? The great question, something a lot of people wonder, and here's the scoop. Objection, Kate. Good to see you. Love this question. All of this is what's called a probable cause determination or a probable cause hearing. There's a thing called the Constitution, and part of that has these different amendments, and the amendments concern different rights that we have. The Fourth Amendment gives us a right to not be prosecuted, arrested, prosecuted, brought to trial without probable cause. You've heard of this concept before. And the 14th Amendment gives us what's called due process. Okay. So after years of common law and interpretation of what these amendments mean, what we have arrived at is that in every case, you have to have a probable cause determination, meaning we don't want the executive branch of the government, the police, going out and arresting people and prosecutors charging them with crimes and bringing them all the way to trial unless somewhere along the line, the judicial branch of the government has made a determination that there's probable cause to do so. So somewhere along that line, early on, we ask that a judge make an independent assessment of the facts of the case to see, is there probable cause to bind that person over, hold that person to answer, whatever each jurisdiction calls it, to allow that person to go and face trial. So most cases that's done through a prelim, a judge, not a jury, not as much evidence, not beyond a reasonable doubt, not the higher standard of proof, sits down, here's the evidence, witnesses are called, and says, yes, I believe there's probable cause to hold this person to answer for trial. That's called a probable cause determination. In some cases, rather than going through the judge, some jurisdictions will use a grand jury. We've talked about a grand jury before. That is the question that's being asked of them. Not is this person guilty beyond a reasonable doubt, but is there probable cause to believe that this person committed this crime on this date? And if so, they hand down an indictment. Both of those serve the exact same function of a probable cause determination. Now, some states only do grand juries. I believe Massachusetts only does grand jury. Some states do both. California does prelim and grand jury. And it's up to the prosecutor on each case what they're going to do. The vast, vast majority are done through prelim because they're just faster and easier. You've got one judge hearing a few witnesses and you move on to the next. In fact, here in Los Angeles, there's an entire unit that all they do all day long in the prosecutor's office is prelims, day after day, prelim after prelim. I was a part of that unit at one point. A lot of people go through that unit. And literally every single day I would show up to work and I might have 8 prelims on calendar for that day. And you sit there and you do prelim after prelim after prelim, moving the conveyor belt along. If you had to convene the grand jury for every single one of those, everything would grind to a halt. You convene the grand jury for incredibly complex cases, multiple defendants, several different crimes taking place over several different dates, or incredibly high profile stuff because it's all kept secret until an indictment is unsealed. In other states, though, that's how they do everything. And on the federal level, that's usually how they do things, is through the grand jury. So it's all just kind of a pick your poison sort of a situation, but they basically accomplish the exact same thing. They just do it in a different way. It's about determining, is there probable cause to hold this person to answer? Or are we locking someone out and accusing them of a crime that there's not even probable cause, enough evidence to support them being accused of this crime? All right, great question. I could probably talk about that more, but I'm running out of time. Let's keep it going here. Helen's Scottish llama. Wow. Helen Scottish Llama. By the way, opening up at Coachella this year, if you're interested in seeing them. BK, autistic sensory overload rather than taunts. Maybe, could be. Great point there. He's got a rude awakening coming to him. All right.
Hi, Josh and CC crew members. This is Tendai from Johannesburg, South Africa. I hope everyone is having a wonderful Sunday morning or afternoon, like it will be for me. I just wanted to comment on the Taylor Schabusiness case, where she is now on trial for a case that she has caught while in custody. She basically attacked a nurse or healthcare provider while she was receiving medical treatment, and then the guard came in and she assaulted the guard, or she had attacked the guard. So now she's on trial for that. So that's why now she has attacked a second attorney. And I just wanted to know, why are they taking it to trial instead of just adding a punishment to her current sentence? Because, I mean, she is serving life, so I'm not sure what else they can do. But yeah, I just wanted to find that out.
Tindai from Johannesburg, South Africa. Let's put you on the map. Hello to all my South African friends. I know we've got a lot of big grizzly contingency down there in South Africa. Hello to all of you. Thank you so much for calling in. Taylor Schabusiness. What an absolute gem. Just about as crazy as you want to get. Taylor Schabusiness, obviously in prison because she murdered her lover in the midst of lovemaking, and then dismembered him, head in a bucket, all of the highlights. And then she's become, if that wasn't crazy enough, and if that wasn't notable enough, she's also really become a fan favorite because she continues to attack her attorneys in court and cause a bunch of mischief. What I love about this, the poor gentleman there sitting there, she, somehow why she's unshackled, not brought in a Hannibal Lecter type get up is beyond me. Goes after her poor attorney. This is not the first time. And I just love it that she's still in pigtails. Somewhere along the line, she has told some judge, or not judge, some guard that she wants pigtails, and then she goes and commits a brutal attack like this. So while she's been in prison, she was being taken to the infirmary for a staple in her arm. Don't ask me how it got there. I don't know if it had to do with surgery or something, or if we're talking about an actual staple from a stapler. She goes in there to have it removed from her arm. The nurse is working on her arm. She lunges at and attacks the nurse. A guard gets involved to intervene, and she attacks the guard with a chair. She is being prosecuted for that. Tindai's question is, why? Why are we wasting time on going to trial? She's going to trial on it. She's going to have a jury. She's going to have everything. She's sit there for a trial on this case, which does happen. There's an entire unit of prosecutors in every jurisdiction that has a prison. They have plenty of prison cases that they take to trial. A lot of them are very brutal. Murders take place in prison all the time. Why do they get a trial? Tindai says, just tack it on. Give her another 10 years on the life sentence she's already serving. Well, this is a great bookend to the last question, because as abnormal and psychopathic as Taylor Schabusiness might be, she's still got constitutional rights. She still has Fourth Amendment probable cause and 14th Amendment due process rights. And part of that says, if you're accused of a crime, you get to fight it if you want to. You get to have a jury. You get to have a judge. You get to call witnesses. You get to cross-examine people, and you get to have your day in court. And so that's exactly what's happening here. her, like anybody else, has the same right to a trial, and these types of inmate perpetrated crimes go to trial quite a bit. Thank you for that. Hello to Johannesburg. Hello to South Africa. Appreciate all of you. All right, guys, we're down to our final question. Where is the jet going to last for its final time? What a great day. What a great Sunday, right? A lot of Bryan Kohberger, a lot of Donna Adelson, Gupta case. I think it's going to be a fascinating one. All right, who's bringing us home here?
Hi, Joshua. This is Linda calling from Red Bluff, California. And I have a question about the Donna Adelson trial. I know it's been mentioned a couple times that Donna will probably be presented as this poor, fragile little grandma. And I'm wondering if the state could possibly bring that in as part of their questioning, as far as like asking maybe Wendi about her mom's character and the way she dressed, or other people that they're going to call if they know Donna and how she's been in the past, so that they could show that this picture of Donna that they're presenting now is strategic to make her look like she's weak and didn't know what was going on. Just curious. Looking forward to your answer. All right. Bye-bye.
Linda from Red Bluff, California. I've said it before. I'll say it again. We have the smartest audience on YouTube. I love this question. Sweaters and tissue boxes. Exactly. I love this question because it is so perceptive, and it brings up the issue of character evidence and when it can be used and when it can't be used. And I agree with you. I think, to Alicia K. Mayo's point, she's going to walk in, and when she testifies, we're going to see nothing but sweaters, lace collars, and tissue boxes, because she's going to present as the sweetest grandmother who wouldn't harm a flea. And how could she possibly be the mastermind behind this brutal assassination? And she's just so beside herself that she's even being accused of something so horrific. Lots of pearl clutching, as they might call it. And Linda says, well, can the prosecution ask questions about that? And the question you're asking, though you may not know it, but you're perceptive enough to pick up on the concepts, is Donna putting her character at issue by taking the stand and by presenting this grandmotherly figure as we expect that she might? So prosecutors are not allowed to call character witnesses simply to talk about a person's character. You cannot call a witness to say, she's brutal, she's awful, and therefore, if she's accused of murder, you should probably believe it because she's somebody I believe who could commit murder. Where you can, though, is when the defense makes their character an issue. So if the defense were to say, call a witness to say she's the sweetest old lady that you ever did see, and she never would harm a gnat, and therefore she couldn't have committed this crime, you can call witnesses to rebut that character evidence. But are they putting her character at issue by simply having her pull a Sean Diddy Combs in court and dress, kind of like a sweet old lady and put on this act in front of the jury? And the answer is no. But a clever prosecutor, I think, can find opportunities for that. If she really makes a show of the, having a tough time paying attention and being, I don't know. I don't know what kind of an act she's going to put on, but you can ask questions that might flesh out more of her personality without putting her character at issue through witnesses. Oh, when she, when you were talking to her about that, was she timid? No, she's not a timid lady. Oh, okay. Maybe some of that would be objected to, maybe not, but I think you can be clever about it, but they cannot just call a witness to say, I've never seen that woman in a lace collar and sweater before in my entire life until this first day here in court. And I've never seen her shed a tear until she testified. Yeah. Wait until you read that poor little grandma's emails. Yeah. Quite a very different, and maybe that's enough. Maybe that reading the emails might be enough to combat that perception. Yeah. She didn't look like a little old lady during the bump. All right, you guys, that was, like I said, don't go anywhere. We have a giveaway we're going to talk about, but let me give you some quick announcements. First of all, if you would like to participate in next Sunday Fun Day, and you're saying to yourself, how do I leave a message? Well, you go to thecourtroomconfidential.com. You click on that little red tab to the right, and you can leave us a message. If you're curious about becoming a member of Courtroom Confidential, which many of you have today, and I hope that many more of you decide to, you go ahead and click on the membership tab, and you'll be sent to this page where you click on the join the CC crew tab, and you can join up. Merch. We've got new merch coming out, everybody. Again, on thecourtroomconfidential.com, click on the shop button, and you can find out about some brand new colors that we have in shirts. We've got new tumblers, which are very cool. A lot of fun stuff that Tiffany and Kaylin have been working on. New hats, snapback hat. I still want my hat. Don't know why it hasn't been ordered yet, including this brand new shirt. What color is this, Tiffany? What is this? If you guys can't tell, it's kind of a shade of green. I'm going to guess that the word moss is somehow used in the name of this shirt. Kaylin's telling me no. All right. Well, I tried. While we're finding out the name of that, Bay. It's called Bay. Like Ocean Bay? I thought it was Bay, like B-A-E Bay. I'm going to call it Bay Green. While we're chatting about that and you're deciding to sign up for the membership or buy a bay leaf colored shirt, I want to talk to you about something we're very proud to announce here on Courtroom Confidential, and that is for the first time ever, we have a sponsor. We, if you have noticed, if you've been watching this live, did not interrupt any of this with advertisements. We turn them off while we're doing live streams, and we hope that we are able to continue to do that. And the way that we can do that is through a sponsorship. And our first ever is Aura. Aura is the best way I think to describe it is as a all-in-one digital security platform. If you are having trouble with robocalls, I get them all the time. Spam emails, I get them all the time. Or I should say I used to. You're worried about your personal data. You're worried about leaked passwords. Aura is the platform for all of that. Either click on that, scan that QR code, or go to aura.com/courtroomconfidential, and you can get 14 days free just to check it out. They will give you alerts for when your information has been leaked, a VPN, an antivirus, password manager, ID theft insurance, and US-based support 24 hours a day. Like I said, it's a great product. It's free for 14 days, and it's also a great way to support the channel. So please, please, please check it out. What did you miss on Saturday? On Saturday, we had the weekly roundup. We talked about that a couple of times. We talked about Donna Adelson and Neha Gupta and Nicholas Kassotis and Brian Walsh and Drummond, all of the big cases that took place throughout this week. Please check it out. It's already up on the channel. Stay tuned next week. Like I said, Donna Adelson's trial is starting. Thank you so much, Ms. Conduct, for becoming a member. That will be over on Courtroom Confidential live trials. Whenever opening statements begin, watch it there. Actually, I think Monday is her last hearing. So I think we're going to try to stream that live. Whenever Donna Adelson's in court and there's a live hearing, we're going to be putting that up, and we will be covering every day of the trial on our Courtroom Confidential live trials channel. Please go. It's a different channel, so go subscribe over there as well. Then on Monday evening, we are doing our live Monday night special with true crime updates, to be determined guest, and to be determined topics. Same thing for Wednesday. Live at 5 p.m. Pacific, 8 p.m. Eastern, to be determined, but it's going to be fun. That's the one thing that is determined, is you're going to enjoy it. CrimeCon is coming up. We talked about that a little bit earlier, but CrimeCon is coming up on September 5th through 7th. Wow. That's really coming up quick. It's in Denver. We hope to see as many of you there as we can. And if you need a little extra nudge, use our discount code courtroom, all caps, all one word, at checkout for 10% off. And if you needed more of an excuse other than to see all your friends and see all the true crime creators that you are big fans of, Courtroom Confidential has been nominated. We're very honored to be nominated in the category of Podcast Outstanding Episodic Series. And I don't know, it might be fun. Maybe we'll win, but we're going to an awards dinner, and we're looking forward to it. We're 50 away from 55K. All right, we're going to sit here until we find 50 people to subscribe so we can hit 55K live, because that is one of Tiffany's most favorite things in the world, is when we hit a milestone live. All right. While we're waiting for those 50 people to show up, here's something fun. Every month for our members, and this is why we encourage you to become a part of our membership, is we do a giveaway. And this month's giveaway, Tiffany's becoming more and more creative with these things, is that we had a name the color contest. So one of our new colors is this blue right here. And we asked our members to suggest names. We couldn't pick one, and we didn't feel it was fair if we picked the winner. So we have our top 3. You can vote after the show. Tiffany's going to send a poll, I guess, in the membership tab. So if you're a member, go to the membership tab and you can vote on, these are the 3 finalists. CC Crew Blue. Love that. Blue Process. You get it? It's like due process, but it's blue process. Or Juicy Winkle, which just Juicy Winkle. So CC Crew Blue, Blue Process, Juicy Winkle. Those are our 3 finalists. The members will pick a winner, and then the winner will be announced tomorrow night, and you win a free shirt. That's the giveaway. You don't have to pick the blue shirt. You can pick whatever you like. A free shirt that we will send to you, and more importantly, you get bragging rights, which no one can ever take that away from you. Shy Gal, thank you so much for gifting the membership. Crazy Mom RN, thank you so much for gifting a membership. All these people can now vote. Objection 403 for gifting a membership. Tracy from Florida for the super chat says Attorney Melanie Little on Aaron Spencer. Not quite sure what that's all about, but I do know Attorney Melanie Little, and I know about Aaron Spencer. So thanks for bringing that up, Tracy from Florida. All right, you guys, you're all fantastic. I hope you have a wonderful rest of your Sunday. Thank you to everyone who asked a question. Thank you to Eric Sadal, my good buddy, for answering a question for us while he was on a rollout. Thank you for all the super chats. Thank you for the gifting of memberships. Always love to have more people involved. And thank you to Kaylin, who makes everything work so smoothly. Thank you to my wonderful wife, Tiffany, for making all things possible. And to our mods, Afton, Sonia, Kathy, and therapists you know. Have a great rest of your Sunday, everybody. Take care.